Ага. Доброго дня, шановні колеги. Засідання спеціалізованої вченої ради в Національному університеті Одеської юридичної академії. Протокол номер 1, 15 липня 2024 року. Слышно? Шановні члени спеціалізованої вченої ради, радий бачити вас. Сьогодні відбувається захист дисертаційного дослідження Кос'яненка Сергія Олеговича на тему принцип аудиокари у міжнародному праві. Ми збиралися з вами в складний для нашої країни час. На жаль, ми не маємо можливості всі збиратися в стінах Національного університету Одеської юридичної академії для проведення захисту дисертації, тому проводимо наше засідання з використання платформи Zoom в режимі реального часу, з проведення прямої трансляції засідання на платформі YouTube. Хочу зазначити, що безпека – це найголовніше. Бережіть себе. Розпочинаємо засідання спеціалізованої вченої ради. Спеціалізована вчена рада утворена наказом Національного університету Одеської юридичної академії від 8 травня 2024 року номер 1058-10 про утворення разової спеціалізованої вченої ради для присудження степеня доктора філософії. Дозволяють мені розпочинати засідання нашої ради, яким присутні Бетхрус Хашматуллах, завідувач кафедри міжнародного та європейського права Національного університету Одеської юридичної академії, доктор юридичних наук, професор. Опоненти, офіційні опоненти. Путник Віталій Володимирович, професор кафедри міжнародного права Львівського національного університету імені Івана Франка, доктор юридичних наук, професор. Пилипенко Володимир Пилипович, доцент кафедри міжнародних відносин, суспільних комунікацій та регіональних студій закладу вищої освіти, Львівський університет бізнесу та права, доктор юридичних наук. Рецензенти. Пасічник Олена Владиславовна, доцент кафедри міжнародного та європейського права Національного університету Одеської юридичної доцент. Кузьмін Едуард Едуардович, доцент кафедри міжнародного та європейського права Національного університету Одеської юридичної академії, кандидат юридичних наук, доцент. Отже, всі члени ради є, кворум є, тому можемо розпочинати засідання. На порядку денному захист дисертації поданий на здобуття ступеня доктора філософії галузі знань 08 права за спеціальністю 081 права Кос'яненка Сергія Олеговича на тему принцип аудиокари у міжнародному праві. Дисертація є рукопис. Робота виконана Національним університетом Одеської юридичної академії на кафедрі міжнародного та європейського права. Науковий керівник, доктор юридичних наук, професор кафедри міжнародного та європейського права Національного університету Одеської юридичної академії Андрейченка Світлана Сергіївна. Шановні члени ради, тепер ознайомлю вас всіх з поданими здобувачем документами, які відповідають установленим вимогам. Почну з короткої біографічної довідки про здобувача. Кос'яненка Сергій Олегович народився в 1999 році. В 2019 році в Національному університеті Одеської юридичної академії здобув бакалавр за спеціальністю права з відзнакою. У 2020 році в Національному університеті Одеської юридичної академії здобув ступінь вищої освіти магістр за спеціальністю права з відзнакою. У 2021 році закінчив університет Іскес у Сполученому Королівстві за спеціальністю права, а також у 2022 році здобув ступінь магістра у Королівському коледжі Лондон з відзнакою. У 2021 році вступив до аспірантури Національного університету Одеської юридичної академії, спеціальність 081 право. Наразі працює в освітній корпорації в головному офісі в Лондоні на посаді керівника проєктів. Також у 2024 році працює в Міжнародному гуманітарному університеті на посаді віце-президента за інноваційної діяльності та маркетингу. Тема дисертаційного дослідження було затверджено на засіданні вченої ради Національного університету Одеської юридичної академії, протокол номер 4 від 10 листопада 2020. 19 квітня 2024 року результати дисертаційного дослідження Кос'яненка Сергія Олеговича були обговорені на фаховому семінарі кафедри міжнародного та європейського права Національного університету Одеської юридичної академії. Кос'яненко Сергій Олегович під час навчання в аспірантурі Національного університету Одеської юридичної академії повністю виконав індивідуальний план наукової роботи та індивідуальний навчальний план, про що свідчить академічна досвідка. Основні положення та висновки досліджень відображено в 12 наукових публікаціях, в тому числі 4 статтях, наукових періодичних фахових виданнях, рекомендованих МОН України, 2 статтях періодичних наукових зарубіжних виданнях, а також в 6 тезах доповідей на науково-практичних конференціях. Висновок наукового керівника, доктора юридичних наук, професора Андрійченка Світлана Сергіївна, позитивний та поданий до Ради. Представлені документи повністю відповідають вимогам порядку присудження ступеня доктора філософії та скасування рішень разової спеціалізованої вченої ради закладу вищої освіти, наукові установи про присудження ступеня доктора філософії, затвердженого постановою Кабінету міністрів 22 року, номер 44. Чи запитані до мене до задавача щодо поданих ним документів, то їх відповідальності встановлено вимогами? Немає? Дякую. Дякую. Здобувач висловив бажання викладати основні положення дисертації та відповідати на запитання англійської мови. Які будуть пропозиції або зауваження?
Підтримати.
Дякую. Mr. Sergey, it's your turn. You are welcome.
Thank you very much. Dear Chairman, dear members of the Specialized Academic Council at the National University Odessa Law Academy, dear participants, I am sincerely grateful for the opportunity to present the results of my research, which aimed to reveal the content, nature, scope, and features of the application of the aut judicare principle in international law. The threat of international and transnational crimes has increased to unprecedented levels in recent years, posing unprecedented challenges to international security in general and to the national security of states in particular. As part of efforts to eliminate impunity for these crimes, the obligation to extradite or prosecute has important practical implications. As a fundamental principle of extradition and international criminal law in general, the application of aut judicare clause is essential for the accountability of people who have committed crimes of international concern by ensuring that they are prosecuted and punished within the relevant jurisdiction. With the beginning of the Russian armed aggression against Ukraine in 2014, which turned into a full-scale invasion on February 24, 2024, the legal content and practical implementation of the principle aut judicare acquires special importance. Human rights are being massively and grossly violated, and thousands of international crimes are being committed on the territory of Ukraine, which requires in particular the cooperation of Ukraine and other states on criminal matters and ensuring the punishment for crimes committed. It is crucial for Ukraine to minimize impunity for crimes committed through international cooperation, specifically due to the application of aut judicare principle, while adhering to existing international standards regarding extradition and prosecution. The principle of aut judicare is considered through the prism of 3 interrelated aspects. Firstly, the protection of interests of the international community, preventing impunity for committed international crimes and ensuring international order. Secondly, protection of the interests of a state, requesting and requested regarding the extradition. Criminal prosecutions and criminal jurisdiction, in particular universal jurisdiction. And thirdly, the protection of the rights and interests of person subject to prosecution or extradition. Despite the fact that the principle of audedere judicare has been widely reflected in numerous international treaties, state and judicial practices, the application of audedere judicare principle raises a number of complex questions that are discussed and debated both at the legal and political levels, and require careful examination and resolution. These questions include, but are not limited to, defining the range of crimes covered by the audedere judicare principle, the hierarchy between the obligation to extradite and prosecute, consistency between treaties containing the audedere judicare clause, ambiguity on the existence of customary obligation, audedere judicare, connection between amnesty and audedere judicare obligation, and absence of a universal international treaty regarding the audedere judicare obligation. The scientific novelty of the obtained results is that the dissertation is the first comprehensive monographic study in Ukraine of the audedere judicare principle in international law. The main theoretical and practical results are specified in the following provisions. For the first time, the principle of audedere judicare is comprehensively considered through the prism of three interrelated aspects. Firstly, protection of the interests of international community. Secondly, protection of the interests of states regarding the extradition, criminal prosecutions, and criminal jurisdiction. And thirdly, the protection of the rights and interests of persons as a subject to prosecution or extradition. The author's definition of the principle of audedere judicare is proposed, taking into account three possible alternatives and purposes of the principle. The audedere judicare principle establishes either the obligation to extradite the alleged offender or to transfer the case to the competent authorities of the requested state for prosecution, or to surrender an alleged offender to a competent international, hybrid criminal court or tribunal in order of ensuring international order, protection the interests of requesting and requested states, and ensuring rights of persons involved in criminal proceedings. The periodization of the development of audedere judicare principle is proposed, taking into account the evolution of the doctrine and practice of international criminal law. The period of the initial general contours of the principle of impunity, which were formulated in the works of such authors as Vittorio, Grotius, Vattel, the 16th, the 18th centuries, the period of active development of extradition, and origins of the customary obligation to apprehend or punish alleged perpetrators of certain crimes. 18th to the middle of the 20th century, the period after 1940s to 90s of the 20th century, the emergence of the international criminal tribunals ad hoc, the development of universal jurisdiction, and inclusion of the audedere judicare clause in international, multilateral, and bilateral treaties on combating international crimes. The period of the 90s of the 20th century to present improved the understanding of the fulfillment of the obligation to prosecute, which is determined by the number of actions, to conduct a preliminary inquiry, to submit the case to the relevant judicial authorities for prosecution, to fulfill the requirements regarding the timeliness of prosecution, to adopt the necessary legislation in order to criminalize certain types of conduct, to implement the relevant jurisdiction, to cooperate and to exchange information with other states or international organizations. Understanding of the relationship between the two obligations to extradite or prosecute set forth in the principle of audedere judicare, construction that favors extradition over prosecution, construction that favors prosecution over extradition, pure model. The provision that in case of appropriate treaty provisions, the principle of audedere judicare provides for the implementation of a third alternative, along with extradition and prosecution before the state's own courts, namely the state in whose territory the alleged offender is located, may be able to satisfy its obligations through the transfer of such person to an international criminal court or tribunal, triple choice model. Justification of the difference between the categories of universal jurisdiction and audedere judicare. Provisions regarding the interaction of the audedere judicare principle with the concept of erga omnes obligation and jus cogens crimes acquired further development. The provision that the obligation audedere judicare arises not only from the provisions of specific international treaties, but also from customary international norms at least with regard to certain categories of international crimes, namely in relation to Jew-Kogan crimes. Characteristics of national legislation as an important source of the obligation to extradite or prosecute. As a result of the conducted research, the solution of the scientific task, which is important for a science and practice, has been achieved, and the following conclusions have been reached. The evolution of the audedere adjudicare principle demonstrates the undeniable development of international law in this area. At the same time, a decade of study of the topic, obligation to extradite or prosecute. Audedere adjudicare of the ILC has not produced substantive results, such as draft articles on the obligation to extradite or prosecute. For this, the political will of the states was not enough. Meanwhile, the research conducted by the ILC is of great value to scientists as well as law enforcement officials. The principle of audedere adjudicare is reflected in numerous conventions aimed at combating international and transnational crimes. It has been established that such conventions are of different types, relate to both international crimes and ordinary crimes, universal and regional conventions, international humanitarian law treaties, treaties against genocide, enslavement, piracy, the hijacking of aircraft, drug trafficking, terrorism, and others, as well as bilateral extradition treaties. Conventions containing the audedere adjudicare clause can be divided into three main groups, depending on the relationship between the obligation to extradite and prosecute. The first group of conventions establishes the priority of extradition. The second group of conventions establishes the priority of prosecution. The third group of treaties contain provisions that provide an alternative for the state. For now, there are no clear answers as to whether or not an obligation audedere adjudicare with respect to international crimes falls within international customary law. To justify the existence of a customary obligation to extradite or prosecute, the following primary arguments are used. The UN General Assembly three resolutions emphasize the importance of combating international crimes and seeking justice. The gravity of international crimes, these offenses are so egregious that they must not go unpunished and that states have a duty to hold the perpetrators accountable. The existence of an international community, civitas maxima, this concept refers to the idea that international law applies universally to all members of the international community. There should be no safe havens for criminals, and states should cooperate in bringing offenders to justice, regardless of whether the crime were committed or the nationality of the perpetrators. The customary nature of the obligation to extradite or prosecute is confirmed by the fact that the obligation audedere adjudicare is the result not of a traditional process of custom formation, but through the adoption of multilateral and bilateral treaties containing this clause. State practice can take the form of state statements, i.e. opinion juris may be confirmed in verbal statements of the state. The audedere adjudicare obligation related to Jew-Kogan prohibition of torture has acquired customary status and can be evoked even in the absence of treaty provision. The conducted analysis allows to highlight the following arguments against the existence of a customary obligation to extradite or prosecute. The absence of consistent state practice or opinio juris to support the view of customary nature of an obligation to extradite or prosecute. The principle of audedere adjudicare applies only when it is expressly formulated in multilateral conventions on international criminal law. Extradition in the absence of a treaty is only a moral obligation. An obligation to prosecute or extradite does not automatically resolve the question of the scope of criminal jurisdiction available to states. Core crimes have the status of Jew-Kogan and violate the customary international law, which provide for universal jurisdiction over them, but this is not ground for the assertion of the existence of customary rule of audedere adjudicare. Existing state practice on amnesty, exile, and asylum indicates that there is no existing customary duty to prosecute international crimes. Preparatory documents for international documents, for example, the UN Declaration on Territorial Asylum, 1967, testify to the absence of states' desire to adopt international legal norms, but only to establish moral principle on which states can rely. The lack of a clear position by the International Law Commission on the existence of a customary international law obligation to extradite or prosecute. It has been concluded that the obligation audedere adjudicare arises not only from the provisions of specific international treaties, but also from customary international norms, at least with regard to certain categories of international crimes, namely in relation to Jew-Kogan crimes. The conclusion has been reached that the auditare or judicare obligation is tied to the nature of the criminal offense. Any criminal activity can be considered harmful to the interests of states. However, any domestic crime committed abroad is almost impossible to prosecute. International law does not recognize the existence of an obligation to extradite or prosecute for all crimes. Due to the difference in the provisions of the various treaties, it is necessary to determine case by case the precise content of the obligation to extradite or prosecute. The prohibition of crimes arising from jus cogens norms is recognized as an erga omnes obligation. However, recognition of the obligation to extradite or prosecute for jus cogens crimes as an erga omnes obligation is debatable. On the one hand, in international practice, one can find confirmation of the position that in case of commissions of international crimes that reach the level of jus cogens, states are obliged to prosecute or extradite the perpetrators in accordance with their international obligations. And such an obligation has acquired the character of erga omnes. On the other hand, the prohibition of commission of certain crimes should necessarily equal the obligation of state to take specific procedural actions. The mere fact that a particular rule has acquired the state of jus cogens automatically does not mean that it is related duty to prosecute has also gained the status. There are examples of states granting amnesty or asylum to individuals who have committed jus cogens crimes. Thank you very much for your attention.
Thank you, Mr. Sergey, for your report.
Thank you.
Do you have a question? I hope you have a question. Please, Professor Pasechnik.
Thank you very much. I listened to your report and I had a question for you. As a part of your thesis, you discuss international treaties as a source of extradition or prosecution obligations. Depending on the relationship between extradition and prosecution, you propose to divide the conventions containing the auditare aut judicare clause into three groups. Could you please explain your position? Thank you.
Thank you very much for your question, Elena Vladislavna. Of course, the first thing to note is that examination of various sources concerning the obligation to extradite or prosecute is necessary to, in order to define the scope and nature of auditare or judicare obligation in international law. This thesis examines three main models of the relationship between extradition and prosecution. According to the first model, which favors extradition over prosecution, a person can be prosecuted in the state in whose territory he or she is located, only if the state refuses to extradite him or her. This model confirms the position that the state should first decide whether extradition is possible. In the second model, the obligation to prosecute takes priority over, and the possibility of extradition exists only as a possible option. A number of international treaties impose the obligation to prosecute whenever the alleged offender is present in the territory of a state. The emphasis is on the prosecution of the alleged offender. There is also a third model, according to which the state in whose territory the alleged offender is located has complete freedom to choose one of the two options, prosecution or extradition. A state fulfills its conventional obligation if it acts in one way or the other without explaining the reasons that led it to make a particular choice. In practice, states are guided by the choice of the solution there is most compatible with the national legal system. It should be always taken into account when applying the principle of auditare aut judicare that conventions that contain the auditare aut judicare provision do not always provide for a clear legal boundaries within which state must act. Provision of multilateral conventions containing extradition or prosecution obligations differ in their content and scope. This is particularly true of the conditions imposed on states regarding extradition and prosecution, as well as the interrelationship between these two obligations.
Thank you, Mr. Sergey. Who is the next?
Thank you.
Professor Filipenko. You are welcome.
Thank you, Mr. Chair. Thank you very much, author, for your presentation, Sergey. I would like to ask you a question. The question is as following. Currently, in response to Russian aggression, it is necessary to hold the aggressor state accountable for international wrongful acts, as well as to bring the perpetrators of war crimes to criminal responsibility. How can the principle of od dedere ad judicare contribute to ensuring accountability for war crimes? Are there any peculiarities in the implementation of the principle od dedere ad judicare in relation to serious crimes such as war crimes? Thank you.
Thank you, Mr. Benka, for the question. Of course, in the context of war crimes, the principle of od dedere ad judicare, in my opinion, plays a crucial role in holding perpetrators accountable. It creates a legal obligation for states to take action when individuals within their jurisdiction are accused of war crimes, by either extraditing these individuals to face the prosecution in the jurisdiction where the crime were committed, or conducting their own fair and, of course, effective prosecutions. States contribute to the global effort to combat impunity for war crimes. Usually, war crimes are subject to universal jurisdiction, meaning any state can prosecute them regardless of where the crime was committed. This actually strengthens the reach of the od dedere ad judicare principle. At the same time, it should be taken into account that implementing the principle of od dedere ad judicare in relation to war crimes may present some specific challenges and, of course, peculiarities. War crimes often involve complex evidentiary challenges, such as collecting evidence from conflict zones, dealing with witnesses from different regions or countries, and preserving evidence in hostile areas. High-ranking officials, including heads of state, often claim impunity from prosecution. These challenges can, of course, complicate the prosecution of war crimes. Implementing the principle of od dedere ad judicare for war crimes typically requires extensive international cooperation between the states, international organizations, and legal institutions. Additionally, the political and diplomatic considerations involved in cases of war crimes can complicate the implementation of this principle. Ultimately, the application of this principle requires the collective dedication of states to fulfill their obligations under international law, and to work together to address the grave consequences of war crimes.
Thank you. Thank you. Who is the next? Professor Gutnik, you are welcome.
Thanks. Thank you, Cyrill, for your brilliant presentation. It was very interesting. I have also two questions that linked with Ukraine, with armed aggression of Russian Federation against Ukraine. And for me, it's a very important question about some linking about judicial system in Ukraine and this principle. So, the first question, what Ukrainian legal acts provide for the principle of od dedere ad judicare? And the second question, could you please provide an example of the application of the od dedere ad judicare principle in Ukrainian judicial practice? Thanks.
Yes, of course, Mr. Gutnik, thank you for your question, for the two of them, of course. The principle of od dedere ad judicare is enshrined in international treaties and agreements to which Ukraine is a party. Ukraine is a party, for example, to several international treaties that include provisions on extradition, such as the 1957 European Convention on the Extradition or the Hague Convention for the suppression of unlawful seizure of aircraft. This document obliges the participating states to either extradite a person suspected of committing a crime or to prosecute him. In Ukraine, the principle of od dedere ad judicare is enshrined in Criminal Code of Ukraine. Thus, the Criminal Code of Ukraine in Article 10 provides that it is possible to extradite foreign nationals and stateless person regarding the residing in Ukraine who have committed crimes outside Ukrainian territory for criminal prosecution and trial in a foreign state. Also, this article enshrines the provisions according to which Ukraine may take over criminal proceedings, in which the judiciary of a foreign state has not passed a sentence against citizens of Ukraine and foreign nationals residing in the territory of Ukraine who have committed crimes outside of Ukraine, but but who cannot be extradited to a foreign state, or their extradition was denied. Also, provisions on extradition or prosecution are provided for in the Criminal Procedure Code of Ukraine. Regarding the second question on the application of principle of audere judicare in Ukrainian judicial practice, recently Austrian courts have rejected, for example, the request of the Ukrainian authority to extradite the former head of the National Bank of Ukraine, Mr. Shevchenko. He was accused in Ukraine of committing corruption crimes. Shevchenko fled Ukraine in September 2022 and is asking for political asylum, claiming political prosecution. The court of Austria claims that the extradition of Shevchenko to Ukraine is currently impossible, simply because of the martial law. At the same time, the Austrian Prosecutor Office for Economic and Corruption Crimes is conducting an investigation against Shevchenko in the case of embezzlement and money laundering. As an example.
Thank you, Mr. Sergey. Who is the next? Mr. Kuzmin, you are welcome.
Thank you so much, dear Chairman. Thank you so much, dear Sergey Olegovich, for such an exhaustive and prompt representation. Just in the beginning, you were mentioning basically about the perception of this principle as some certain kind of obligation that are divided into three elements, and the third one was an option to surrender to international and hybrid tribunal, but bearing in mind that sometimes we might also face and experience such kind of tribunal as a domestic one or internationalized. Does it mean that this kind of principle and obligation would cover this third one, and especially if we're talking about the Ukraine, so would it spread into a potential special tribunal on Ukraine? Thank you so much.
You are welcome, Mr. Sergey.
Thank you, Mr. Kuzmin. Thank you for the question. Yes, of course, indeed, it probably does require some more clarification from my side. The concept of a third alternative within the audere judicare framework refers to the option of surrendering individuals accused of serious crimes, such as war crimes, to an international criminal tribunal or a hybrid tribunal. This third alternative provides an additional avenue for the prosecution of individuals when neither extradition nor local prosecution are viable or deemed appropriate. The point is that the phrase international criminal tribunal, which is used in such a formulation, is intended to encompass not only the permanent international criminal court, but also all other types of the so-called international tribunals, including ad hoc international criminal tribunals, as well as special courts or tribunals that combine international and national law. Therefore, we are inclined to believe more that the situation in Ukraine should not, and hopefully will not be an exception.
Thank you. Thank you. Let me also ask a question. My question is about the obligation to extradition. In chapter 2 and also in your report, you told and mentioned about question of ground for refusal of extradition. And specifically, you address the issue of human rights protection. Please describe the meaning of the principle of human rights protection within the context of the application of the audere judicare principle.
Thank you very much for the question, Mr. Cruz. Of course, according to international and national law, the extradition may be refused if the extradition would violate international guarantees of human rights. For example, if the extradited person faces the death penalty or are subject to torture, cruel, inhuman, or degrading treatment and punishment, or if the person's rights were violated during the arrest and detention for the purpose of extradition. The principle of respect for fundamental human rights and freedoms as a basic principle of international law is gaining more and more importance in connection with the general recognition that one of the main functions of the state is to ensure compliance with human rights. international cooperation of states in combining crime should not lead to the violation of the rights of persons involving in criminal proceedings, in particular in connection with extradition. Thus, the principle of audidere judicare on one hand contributes to the struggle of international community against international crime, and on the other, it serves as humanitarian purposes to ensure fundamental human rights.
Thank you, Mr. Sergey.
Thank you.
Are there any other questions? No, thank you. Let's begin the discussion of the thesis. I would like to invite our official opponent of PhD thesis, dear Professor Gutnik. The floor is yours. You are welcome.
Thank you,
10 minutes. Because of the 10 minutes, it's enough for you.
Yeah, it's completely enough. Because actually,
because there is problem of electricity.
So first of all, I just want to say that it's a great honor for me to be a member of that scientific specialized council. So thanks a lot for the invitation to be opponent and member of that specialized scientific council, and following the Khashmaghlad Munabiyevich, actually my view as opponent is available on the website of this university. So it seems that it's not. We don't need to repeat the same in my speech. So here I just want to say my main points. First of all, I just want to say that this dissertation audidere judicare principle in international law devoted to very important issue of international law, because we know that this power of state to prosecute any person who commit any crimes in its territory. So in any case, in general, should be some link between state that want to prosecute, or states that has power to prosecute, and a person who alleged committed some crimes, or this territory take into account ratione loci, or territorial jurisdiction. But we have some extraordinary crimes. Some of these crimes is international crimes, but usually international crimes, genocide, crime against humanity, war crimes, and crime of aggression. But here could be some other additional crimes. So audidere judicare is some approach how to additionally fight against impunity for that crime. So it's very important question. And here I just want to add also very important point, that this dissertation is in English. So as usually our scientific researchers are in Ukrainian, so we are close in our country, and when you want to say about yourself in outside, so in other countries, and you will ask it, could you send your scientific research, your articles, your dissertation? And when you say my dissertation was in Ukrainian, so you limited in sharing your scientific research. So it's very nice that that dissertation was written in English. So about, novelty of the dissertation, nullity of the dissertation is showing the legal gray zone imposed by the judicial principle in international law. So in Ukraine, we didn't have until the time similar scientific research. The main provision of a dissertation put on defense are reflected in the author's publication and fully fit to all conclusion. Also provide high standards of the research at both theoretical and methodological level. Dissertation is characterized by consistency. Also demonstrate good mastery of modern method of scientific research, but as all dissertation, this dissertation is few remarks, and I just want to say, because it's very important to say about this. It's not some very huge. It's some. It seems that more technical remarks, but in any case. So first of all, the first question and the first remark regarding Ukraine and that principle. So it seems that and the first remark that the analysis at the level of separate subchapter or even chapter of the practice of applying the principle of judicial in the context of international crimes committed during the Russian-Ukrainian war would be greatly enriched by the dissertation research. The second question, second remark is more technical, that more scientific. I would like to say that in general, agreeing with the periodization of the genesis of the judicial principle in international law, the question arises as to the completion of some of that stage. On page, for example, of page 42, the third state is signed out as the period after 1945 until 1990 of the 20th century, and title of that state emergence of ad hoc international criminal tribunal, the development of universal jurisdiction, and the inclusion of the judicial clause in the international multilateral and bilateral treaties on the fight against international crimes. It's obvious that international treaties were adopted within this state, which provide for the studies principle and which are forced today. For example, Geneva Convention for Protection of Victims of Wars of 1949. In other words, if such these norms are applying today, is this state of the genesis of the principle such that is lasted only until 19th of 20th century. So it seems that it's until that stage is until today. The next remarks, chapter 3, relation between the obligation to extradite or prosecute and other principle explores the relationship between judicial and universal jurisdiction, erga omnes obligation, and jus cogens norms. Based on the title of chapter number 3, one might think that the other principles are universal jurisdiction, erga omnes, and jus cogens. However, neither erga omnes nor jus cogens are principles. Erga omnes are international legal obligation, and jus cogens and mandatory norms of international law. it is fair to know that already in the title and in the text sub-chapter 3.2, it is quote correct to speak of erga omnes obligation, and subchapter 3.3 use Coggins norm. And the last, it's not remark, but 2 questions. What are the trends in the development of the out judiciary principle international law? And the last question, regarding which crimes is it appropriate to expand the scope of the out judiciary principle? And to summarize, I just want to say that actually dissertation is has value. Very important that the dissertation is in English. And to summarize and to say final scientific relation assessment, the doctoral dissertation out judiciary principle in international law by Kos'yanenka meets the requirements for doctoral dissertation, and it has scientific novelty. The conclusion of the dissertation has theoretical and practical significance, and it seems that during summarizing our defense procedure, then I say more about some final conclusion, but it seems that remarks, it's not serious remarks, it's just more technical, so it seems that I will stop here. Thank you again for possibility to be opponent and to say something, some good vision, some good your result. So thank you again.
Thank you, Mr. Professor Gutnik, for your professional review. Please, Mr. Sergey, it's your turn. Give us your response to these remarks and questions. You are welcome.
Of course. Thank you. First of all, Vitaly, thank you very much for those kind words, and it's such a great honor to have you as an opponent. Let me respond to your questions. Regarding the issues of determining the completeness of certain stages of the genesis of audere au judicare principle in international law, indeed, in our opinion, the third stage covers the period after the 1940s and until the 90s of the 20th century, and this characterized by the emergence of international criminal tribunals ad hoc, the development of universal jurisdiction, and the inclusion of the audere au judicare principle in international, multilateral, and bilateral treaties. The fact that the international treaties adopted during this stage are still in force and applied today indicates that the influence of this stage continues in the modern period. Thus, it can be argued that this stage has had a lasting impact on development of the audere au judicare principle. It is worth noting that the development stages may be transitional in nature, when some elements of one stage continue to exist and influence subsequent stages. Thus, the influence of third stage continues, and the development of the audere au judicare principle continues to this day. In regards to the question of trends in the development of the principle audere au judicare, it's important to note that the development of audere au judicare principle is an evolving area of international law, and its interpretation and application continue to the subject of legal scholarship, judicial decisions, and diplomatic negotiations. Among the trends in the development of the principle, the following can be mentioned. The inclusion of this principle in the national legislation of states, the enshrining of the principle in the statutes of international criminal courts and tribunals. Although this principle is not always stated directly, its essence is enshrined in the obligation of imposed on states to cooperate with international judicial bodies. The expansion of the range of crimes that are subject to the principle audere au judicare conventions in the fight against crime adopted in the 21st century contain provisions on audere au judicare. For example, the Ljubljana, the Hague Convention, which was signed in February 2024, outlines the obligation of states with respect to cooperation and extradition in the investigation of crimes under international law. In addition to cooperation between states, the Convention also lays down a principle in the Audidere Judicare. Concerning the issue of expanding the scope of Audidere Judicare principle, the scope of Audidere Judicare principle has been traditionally associated with serious international crimes, including genocide, war crimes, crimes against humanity. However, there are ongoing discussion and debates within the international legal community about the potential expansion of the principle to cover other types of offenses. For instance, environmental crimes such as illegal logging and pollution of international waters, given their global consequences. In this context, the issue of recognizing the customary nature of the obligation to extradite or prosecute for a certain type of crimes is also important. This issue is controversial. The International Law Commission did not express support for a position on the existence of a customary obligation to extradite or prosecute, but did not reject such a possibility. The dissertation provides an examples from judicial practice that demonstrates the customary status of the principle Audidere Judicare. In our view, with respect to specific categories of international crimes, obligation Audidere Judicare arises not only from the provisions of specific international treaties, but also from customary international norms. It's important to note that extending the scope of the Audidere Judicare principle to cover new categories of crimes raise legal, practical, and political considerations. Any expansion requires a consolidated position of states and the achievement of consensus in the form of treaties or practice of application, and is related to issues of state sovereignty, harmonization of legalization, and enforcement mechanism. I, of course, fully agree with all other remarks of Vitaly Vladimirovich and express my sincere gratitude for the attention and high evaluation of the thesis.
Do you finish?
Yes.
Thank you, Mr. Sergey. Dear Professor Gutnik, are you satisfied with the answers?
Yeah, I'm satisfied completely.
It's beautiful, it's great. Okay, thank you, thank you. I would like to invite our official opponent of PhD thesis, dear Professor Kos'yanenka. The floor is yours. You are welcome.
Thank you very much. Thank you very much again, Mr. Chair. First of all, I would like to congratulate the reporter, Mr. Sergey, with the excellent presentation of the dissertation. Actually, it was a pleasure to listen to such a solid speech. Well, research on the topic principle of Audidere Judicare in international law has unconditional theoretical significance and practical relevance in modern international law. The studied principle is a cornerstone in the framework of international legal cooperation in the fight against international crimes. By obliging states either to extradite individuals to a state with relevant jurisdiction or to prosecute them at the national level, the Audidere Judicare principle aims to prevent the evasion of justice. This is especially important in the modern context. International cooperation is necessary to maintain global security. And I actually will not go deep into my opinion related to thesis, if you do not mind, Mr. Chairman, because I am sure all of you are familiar with it. It is public. So again, if you don't mind, I will stop only on some suggestions concerning the significance of the work, and I will point out few comments of mine to hear the position of the author. First of all, I need to mention the dissertation study is the first comprehensive monographic study of the principle of Audidere Judicare in international law in Ukraine. The results of this research presented in the introduction and conclusions are important from the theoretical and practical point of view and have scientific novelty. Among the results of the dissertation work, which determine its novelty, I will especially highlight the following. First of all, for the first time, the principle of Audidere Judicare was proposed to be comprehensively considered through the prism of three interrelated aspects. First, protection of the interests of international community. Secondly, protection of the interests of the state in relation to extradition, criminal prosecution, and criminal jurisdiction, in particular, universal jurisdiction. And thirdly, protection of the rights and interests of persons subject to criminal prosecution and extradition. Second, the periodization of the development of the principle of od dedere judicare was proposed for the first time, I would like to stress it, taking into account the evolution of the doctrine and practice of international criminal law. First, the period of the initial general contours of the principle of impunity, which were formulated in the works of such great authors as Vittoria, Grozzi, and others. Second, the period of active development of extradition and the birth, I would like to say, of the customary duty to detain or punish those suspected of committing certain crimes. This is a period from the 18th century to the middle of the 20th century. This period after 1945 to the 90s of the 20th century. The emergence of ad hoc international criminal tribunals on Rwanda, on former Yugoslavia, the development of universal jurisdiction and the inclusion of the od dedere judicare obligation in international multilateral and bilateral treaties, and the period from the 90s of the 20th century to the present day, the emergence of a permanent body of international criminal justice and other international and specialized courts and tribunals, which led to the emergence of the so-called third alternative as a model of the obligation making od dedere od judicare. Another conclusion, improved understanding of the relationship between the two obligations, to extradite or to prosecute, set forth in the principle of od dedere od judicare. It has been proven that the decision to issue or prosecute should be made by the state in accordance with its domestic legislation and international legal obligations, with an emphasis on fighting crime, preventing impunity, and respecting individual rights, of course. Then I would like to mention that was improved the provision that in the case of relevant provisions of the treaty, the principle of od dedere od judicare provides for the implementation of the so-called third alternative, along with extradition, along with the prosecution in the state's own courts, namely the state in whose territory the alleged offender is located can fulfill its obligation by transferring such a person to an international criminal court or tribunal, so-called triple choice model. And this is very important. Dissertation of Sergei Kos'yanenko also contains other significant and well-grounded theoretical provisions, which testifies to the high scientific level of the conducted research and the achievement of the tasks and the goals set by the author. The scientific level, I would like to stress, taking into account all the above mentioned, is high. At the same time, and despite its positive characteristics, the dissertation research contains some provisions that cause possible comments, as well as some questions that should be answered during the public defense. In particular, I would like to point out only a few of the comments that are mentioned in my opinion, because first of all, it's public, and secondly, because I have already got the answers for the rest of comments during the author's speech today, and I'm actually satisfied with that. So, first of all, I would like to point out first question. Sergei, you define the subject of research as the principle of od dedere od judicare in international law. It's on page 22. Accordingly, in the dissertation, it would be appropriate maybe to provide a definition of the principle in general and the principle of international criminal law in particular. Another question, in chapter 3 of the thesis, the relationship between the obligation to issue or prosecute and other principles, you limit yourself to highlighting the relationship between the obligation to issue or prosecute with the principle of universal jurisdiction, obligations, erga omnes, and violations of jus cogens. At the same time, the dissertation ignores a number of other principles related to the obligation to issue or to prosecute. For example, nullum crimen sine lege, or nulla poena sine lege, or the principle of double criminality, or non bis in idem. In our opinion, the work would only benefit from studying the interaction of the od dedere judicare principle with other principles as well. And the last one, but not the least, of course, in international practice, there are known cases of the use by some states of abducting persons in order to bring them to criminal responsibility instead of carrying out the extradition procedure. I would like to hear your position regarding the application of the practice of kidnapping, which aims to prevent the avoidance of responsibility for committed crimes. Nevertheless, again, I would like to know that all the mentioned remarks, in my opinion, and mentioned here during your presentation, they refer to clarifying debatable issues or individual provisions or thoughts that are not sufficiently clearly formulated and substantiated, which do not affect actually the overall positive evaluation of the dissertation. And of course, I would like to stress that the dissertation research of Sergei Olegovich Kos'yanenko on the topic, the principle of od dedero judicare in international law for obtaining the degree of Doctor of Philosophy in the field of knowledge 08 law with the specialty 081 named law is an independent scientific work which was completed by the author personally. The dissertation contains new scientifically based theoretical research results that are important for the development of science in practice. The said scientific task was performed at high level, and the dissertation itself testifies that the author has mastered the methodology of scientific activity. Dissertation of Sergei Olegovich Kos'yanenko on the topic principle of od dedero judicare in international law for obtaining the degree of Doctor of Philosophy in the field of knowledge 08 law in the specialty 081 named law corresponds to the specialty 081 law and the requirements of the procedure for awarding the degree of Doctor of Philosophy and annulment of the decision of the one-time Specialized Academic Council of the Institution of Higher Education, Scientific Institution on awarding the degree of Doctor of Philosophy. An order of Ministry of Education and Culture, number 40, dated January 12, 2017, on approval of requirements for registration dissertation, and its author, Sergei Olegovich Kos'yanenko, for sure deserves to be awarded the degree of Doctor of Philosophy in the specialty 081 law. Thank you very much for your attention, Mr. Chair.
Thank you, Mr. Dear Professor Filipenko. It's your turn, Mr. Sergei. Give us your response to these remarks and our questions. Please, you are welcome.
Of course. Thank you, Vladimir Petritovich. It is a great pleasure to have you and one of your opponents. Let me respond to your questions. Regarding the question of the application of amnesty and principle of ad dedere judicare in the context of principle ad dedere judicare, the question of the application of amnesty arises because of possible conflicts between the obligation to prosecute or extradite persons accused of certain serious crimes and the granting of amnesty by states. This complex issue involves considerations of international law, human rights, and transnational justice. The relationship between amnesty and the principle of ad dedere judicare has been the subject of debate and has led to legal and political debates on the goals of justice, peace, and reconciliation. Some argue that amnesty for serious crimes undermines ideas of justice and accountability, especially in cases where the international community has a strong interest in ensuring accountability for crimes such as genocide, war crimes, crimes against humanity, and serious human rights violations. At the same time, others advocate a balanced approach that takes into account the complexity of the post-conflict or transitional context, recognizing the potential role of amnesty as part of a broader process aimed at promoting peace and stability. Thus, the application of amnesty in the context of principle ad dedere judicare raises complex legal and ethical issues and requires careful consideration of the specific circumstances and impact on victims, perpetrators, and the wider public interest. One of the questions concerned the practice of abduction. The practice of abduction persons for the purpose of criminal prosecution outside of formal extradition procedures raises complex legal issues in the field of international law. While there is an argument that this approach is a means of preventing the avoidance of responsibility for committed crimes, it is contrary to established legal principles and norms. In the process of extradition, individuals are transferred from one jurisdiction to another in accordance with established legal procedures and standards. Using extrajudicial measures such as abduction to circumvent the extradition process violates the fundamental principles of due process of law, the rule of law, and the respect for sovereignty. The rights of such persons are enshrined in international acts, and the national legislation of states are also violated. For example, the right to a fair trial, the right to legal representation, and the prohibition of arbitrary detention. It is important to recognize that the use of extrajudicial means, such as abduction, to resolve criminal accountability issues can have significant legal and diplomatic consequences. Instead, international law and norms emphasize the importance of cooperation, due process, and adherence to established legal procedures in addressing criminal accountability issues. Concerning the issue of distinguishing the institution of extradition from such related institutions as expulsion, exchange of offenders, return of offenders, yes, indeed, a clear separation of the institution of extradition from other institutions of international and national law is one of the important prerequisites for its proper use. Thus, the institution of extradition should be separated from the institution of expulsion or deportation. A common feature of this legal institutions is the possibility of detaining a person. I want to emphasize once again a fundamentally important point. Extradition is a measure taken against alleged criminals or convicted persons. Persons who are subject to expulsion or refoulement cannot be treated in this way. In addition, there are other differences. Extradition involves two states, while expulsion is a unilateral act. These institutions have a different legal nature, subject matter, and procedure. Expulsion is an administrative measure. The expulsion procedure is not related to a criminal procedure. The next institution to be compared is the exchange of offenders. It is worth noting that extradition can be applied both to criminals, i.e. to persons who have been convicted by a court, and to alleged offenders, i.e. person accused of committing a crime for the purpose of trial, while the concept of exchange of offenders means the transfer of only person to serve their sentence. The following notion for comparison, return of offenders. In legal literature, the term return of offenders is sometimes used. However, it is quite difficult to separate the relation of return of offenders to a separate legal institution. Instead, we should talk about a legal relationship of extradition in relation to a specific case. I certainly agree with other comments and remarks of Vladimir Filipovich, which I will certainly keep in mind during my further research. Really appreciate it. Thank you.
Thank you, Mr. Sergey.
Thank you, Mr. Chairman.
So, dear Professor Pilipenko, are you satisfied with the answers?
Yes, of course, I'm fully satisfied. Excellent answers. Thank you very much.
Thank you, Vladimir Pilipovich. Thank you.
Thank you for our session. Now it's time to give floor to our reviewers. I would like to invite our official reviewer of PhD thesis, the Professor Pasechnik. You are welcome.
Thank you very much. Congratulations, dear colleagues. I want to thank you for the invitation to speak in such a respectful council. Thank you for the opportunity to get involved in the discussion of an extremely relevant topic. When I saw the theme of the dissertation Kos'yanenka Sergei Olegovich, Principle aut judicare in international law, I want immediately to get acquainted with the work. As a part of the effort to safeguard Ukraine's interests in the face of Russian aggression, it's especially important to have additional opportunities to prosecute and punish people who committed crimes under international law in the territory of Ukraine. Democratic states of the world are united in the fact that the perpetrators of international crimes should not remain unpunished. Principle aut judicare, extradite or prosecute, contributes to the fight against impunity for committing criminal offenses. It was a real delight to read this dissertation. The author of this dissertation outlined his own vision regarding the principle audere aut judicare, is considered through the prism of three interrelated aspects. I think that the proposed research vector is very successful. Also draw attention to the normative base, to the empirical base, to the source base of work. Also, dissertation paid special attention to the analysis of conventions aimed of combating international, transnational crimes containing the provisions of audere aut judicare. Briefly, in chapter 1, the author defines the general theoretical legal foundations of the research. The second chapter is devoted to the sources, material elements of audere aut judicare from the point of view of international treaties and national legislation. And chapter 3 examines the relationship between the duty to extradite or prosecute with other principles. Such methods as dialectical, historical legal, comparative legal, instrumental, systematic, formal legal, logical, allow to the author to investigate and substantiate the scientific results of the study. The author of the dissertation has reworked a large amount of literature. I want to highlight the number of sources, 283. It's a huge amount. And most of this literature in English. I think that gave us a presentation, the researcher as a high educated person. Great thanks to the author for using works of Odessa School of Law. For example, works of Professor Sergei Vasilievich Kivala, Professor Natalia Antonovna Zelinskaya, Professor Svetlana Sergeyevna Andreychenko, Professor Behrus Shtanabiyevich, and others. The conclusions are reasonable and absolutely logical. I think that we have original, independent research, which contains a number of suggestions, new recommendations, new statements. I think this work matches all those features that should characterize the scientific research that is submitted for the degree of Doctor of Philosophy. The work itself has a favorable structure, which made it possible to thoroughly and comprehensively consider the chosen problem. And today we are once again convinced that this was not a review, but a detailed study of all the declared literature. If you talk about the achievements of this dissertation, then first of all, we should note those provisions that were formulated for the first time. Namely, the principle of audere aut judicare is comprehensively considered through the prism of three interrelated aspects. It's protection of the interests of the international community. Secondly, protection of the interest of a state regarding the extradition, criminal prosecutions, and criminal jurisdictions. And thirdly, it's protection of the rights and interests of persons as a subject to prosecution and extraditions. Also, the author's definition of the principle of audere aut judicare is proposed taking into account three possible alternatives and purposes of the principle, and about the prioritization of the development of the audere aut judicare principle is proposed taking into account the evolution of the doctrine and practice of international criminal law. The abstracts corresponds to the content of the dissertation and sufficiently reveals the position of the work. Content of the dissertation corresponds to the declared the scientific specialty. Work is independent, completed work, and written in scientific style, no violations of academic integrity. The requirements of academic integrity are fully respected. At the same time, like any scientific research, this work contains some questions. First question, the issue of prioritization of the development of the principle of audere aut judicare is not easy. The fact is that in the process of studying the history of the formation of the principle of audere aut judicare, difficulties may arise both in determining the grounds for dividing into certain stages and assigning a particular phenomenon to a particular stage. The choice of criteria is always for the researcher. It's important that the chosen approach to periodization is scientifically sound and a step towards the knowledge of a legal reality. What criteria guided author of this dissertation in the issue of periodization, the principle audidere aut judicare? For example, why the work of the United Nations International Commission is marked as a sign of the period from the 19th of the 20th century to the present. And the second my question is that researcher in this dissertation study concludes that the decades of work of the United Nations International Commission on the topic obligation to extradite or prosecute did not bring significant result. At the same time, ideas about the sources of such an obligation became a significant obstacle. In this regard, the question arises, since not all states join international treaties devoted to the issue, and countries do not recognize the customary nature of the principle of audidere aut judicare, how can the obligation to cooperate in the fight against impunity be realized? Comments and suggestions made related to controversial issues do not affect the high scientific level of the dissertation, do not question the main scientific conclusions obtained by the applicant. Presented work is holistic study of an important scientific problem, namely the principle of audidere aut judicare in international law. Considering all above what I said, I want to note that the work corresponds to, firstly, for the specialties 081 law, and secondly, requirements of the current legislation for such works. And Kos'yanenka Sergey Olegovich deserves to receive degree of Doctor of Philosophy. Thank you for your attention.
Thank you, dear Professor Pasechnik, for your profound review. Mr. Sergey, it's your turn. Please give us your response to this remark and questions.
Of course. Many thank you, Elena Veslavna, for those warm words. Let me respond to your questions. So regarding the issue of periodization, the periodization of the development of audidere aut judicare principle is proposed taking into account the evolution of the doctrine and the practice of international criminal law. Namely, some key historical moments that influenced the doctrine were identified, such as the theoretical contribution of Vittoria, Grotius, and Vatel to the formation of the initial contours of the principle, the 16th to the 18th centuries, the active development of extradition and the emergence of customary obligation to apprehend or punish alleged perpetrators of certain crimes in the 18th century to the middle of the 20th century were found. The following significant milestones for the development of the principle were the emergence of the international criminal tribunals ad hoc, the development of universal jurisdiction and inclusion of the audidere aut judicare clause in international multilateral and bilateral treaties on combating international crimes. The period after 1945 to the 90s of the 20th century, from the 90s to the present, the following important aspects have been observed. The emergence of a permanent body of international criminal justice and the international and specialized courts and tribunals, the work of the UN International Law Commission on the subject of the obligation to extradite or prosecute. Particular attention should be paid to the work of the UN International Law Commission. The UN International Law Commission plays an important role in the codification and systematization of international law, including principles related to the obligation to extradite or prosecute. The Commission developed draft articles, conventions, and other international documents, which can then become the basis for conclusions of international agreements. The documents include provisions on the obligation of states to extradite or prosecute. There is also an influence on national legislation. After all, the Commission's recommendation and projects have a significant impact on the national legislation of the UN member states regarding issues, extraditions, and prosecution. The second question concerns the problem of states' implementation of the obligation to cooperate in fight against impunity. in particular due to the fact that not all states join international treaties containing the principle audedere aut judicare, and the states do not recognize the customary nature of the audedere aut judicare principle. When states do not join international treaties, which include the provision of audedere aut judicare, or do not recognize in customary nature, it really creates difficulties in implementing the obligation to cooperate in the fight against impunity for international crimes. However, there are some mechanisms and approaches that facilitate the implementation of this obligation. For example, universal jurisdiction. Some states can incorporate the principle of universal jurisdiction into their national laws, which allows them to prosecute individuals for certain international crimes, regardless of whether the crimes were committed or the nationality of the perpetrators. Another important mechanism is international criminal justice, namely the work of the International Criminal Court, international tribunals that have jurisdiction to consider cases related to international crimes. International cooperation is also an important point to be considered. Recognition of the seriousness of international crimes and interest in ensuring security and justice contributes to joint efforts in the fight against impunity. The importance of international pressure and diplomacy should also be highlighted. The International Committee can use pressure and diplomatic efforts to uphold the principle of audedere aut judicare and engage states in the fight against international impunity.
Thank you very much. Absolutely satisfied with your question. Thank you.
Thank you, Thank you.
Thank you for. Now it's time. I would like to invite Professor Kuzmin to have his review. The floor is yours.
Thank you so much, dear Chairman. Thank you so much, dear colleagues. I'm flattered, and it's a great honor to be here. That's because Sergei Olegovich demonstrates the first-time experience, and the analysis of the manuscript shows that it might be able to outperform. So my attitude was, whenever I was trying to get acquainted with the text of the PhD thesis, I was really amazed as the author is not trying to describe the phenomena in English, avoiding the thorough examination, but rather to represent his own ideas and critical approach that feels throughout the whole text of the dissertation. As a reviewer, I have to criticize a little bit, and also there is a very tough assignment for us to analyze the manuscript towards the formal criteria and also the merit of the text. I would also probably follow the logic of the previous professors, not to dive into much details, but to emphasize my personal overall perception of the manuscript. The first thing is that we do believe is necessary to emphasize is the idea, the general idea. And we had a chance to understand that probably needless to say that how urgent this topic is, and the thing that I referred this kind of idea with Sergei Olegovich attempt is scientific courage. So it is something that is a very complicated task, and during such a situation here in Ukraine, we might only see that every single question today after the representation was about the situation in Ukraine, and that is something that might also be a very complicated puzzle and a very extremely fragile topic to discuss, and Sergei Olegovich did conducted such a research, and that is a great reason for admiration. The second thing is formal criteria, as we had to eliminate everything that I'd like to assure colleagues that everything matches the current requirements, and every single obligatory element is just in there, and also the text, even from the language element, if we might see the perspective, it was neatly done, and there was lots of interesting ideas, but the results were never compromised. So it is on the decent level, both in English and according to the merits. And yet again, according to the merits, the idea is something that we've never perceived before, and that is all about the scientific novelty. It was extremely pleasant to understand how Sergei Olegovich is perceiving this kind of principle. And what I was personally amazed of is something that is a comprehensive character. The problem of the principle that was mentioned before is that his multi-faced and comprehensive nature, how we might treat it from a political side, from a philosophical point of view, or any other perception, as an obligation, as a maxima, as a principle, as something else. That is also a very tricky question, but the author conducted an amazing and basically accomplished an amazing effort to cover and combine everything. What I might emphasize is that it is a very rare position when professors are treating this principle as something that goes to this third alternative and third pillar that is a very urgent question, is very peculiar here in Ukraine, and I was amazed and very pleased to have that as a part of this research. So it is a very positive way how we might treat this principle. So eventually, like to conclude also, as it is a very thorny and a long-lasting road, some mishaps might be in there. That's because the origins of this topic is rather discussive and debatable. And from where I stand, I was trying to understand. So there was, to my mind, a couple of arguments were missing, and I might understand why that's so. That's because the size of the manuscript is not infinite, and that is something that was a factor of that limit. But I was trying to understand what was the argumentation for the evolution of this kind of principle from the Grotius formula. I was amazed by this philosophical idea of the work as the solar and monumental pillar of the work. But why do we have to switch from this aut dedera punire, as either we are transferring a person or we are punishing? That is something that I'm struggle for. But today we have to talk about the prosecution probably, and it was in the text of the theses, but I felt like I need some more details about that, and I'm just interested and curious about the author's opinion. And the second one is all about the jurisdiction, as our prominent opponents were mentioning and highlighting a couple of different perceptions of this universal jurisdiction. So the question that I was thinking that would be appropriate to arise is, how can we delineate that? That's because the text of the manuscript demonstrates us basically two definitions of these terms, but what are the criteria to prove that they're different, how we might differentiate among these kind of phenomenon? That is something that I've been puzzled. The rest of the issues, and to sum up, not to spend any more time on that, I'd like to say that it is something that just simply needed to be published. This is the first key thesis, and probably in the commentary part, I would stop on these kind of questions to be more detailed. And the second thing is that obviously everything is neatly done. It is the very holistic and monolithic research that allows us to believe that Sergei Olegovich deserves this kind of title, and it is something that might serve as a decent conclusion. Thank you so much.
Thank you, dear professor, for your profound review. Thank you. Mr. Sergey, it's your turn. Please give your response to this remark and questions.
Thank you, Dr. for the warm words for the respected review. Let me respond to your questions. Regarding the first question, the point is that the basic idea was the following: from the historically first idea of handover or punishment, it evolved into extradite or prosecute. And now it seems to reflect the reality more through the concept of human rights and principles that a person cannot be punished because he or she may be innocent. Thus, the most that can be legally demanded from the requested state instead of extradition is to prosecute the person officially. Therefore, today, in our personal opinion, it is appropriate to talk not about extradition and punishment, but rather about extradition and prosecution. In relation to the second question regarding the distinction between the principle of audere autodicare and the principle of universal jurisdiction. These principles are both mechanisms in international law aimed at ensuring that individuals who commit serious crimes do not evade justice. However, audere autodicare is focused on extradition or prosecution based on mutual agreements between states, while universal jurisdiction allows states to prosecute an individual for specific grave international crimes based on the ground that such crime concern in international community as a whole. Thus, audere autodicare is a rule, treaty-based, and involves a specific request for extradition, obligating the state to either extradite or prosecute the individual. Universal jurisdiction allows any state to prosecute certain grave international crimes without needing an extradition, request, or any other connection to the crime, suspect, or victims. It is also important to consider that the list of crimes covered by the principle of audere autodicare is more extensive, as it covers a wide range of serious international and transnational crimes regulated in detail by various international treaties. The principle of universal jurisdiction covers only a limited set of grave international crimes, including but not limited to genocide, war crimes, crime against humanity, and certain forms of terrorism that have an impact on the international community as a whole. Audere autodicare obligation entails the transfer of proceedings to the competent authorities for prosecution or extradition, not the establishment of jurisdiction. In order to fulfill the obligation audere autodicare, the state must already have passed laws criminalizing certain acts. Audere autodicare obligation is not limited to situations in which a universal jurisdiction is required to be applied for the prosecution or extradition of individual.
Thank you, Mr. Sergey.
Thank you.
Mr. Kuzmin, are you satisfied by answers given by Mr. Sergey?
Yeah, thank you so much.
Thank you, Mr. Kuzmin. Thank you.
Дякую здобувачу і членам разової спецради за надану оцінку дисертації. Також хочу визначити, що до спеціалізованої вченої ради надійшли завірені на дисертаційне дослідження Кос'яненка Сергія Олеговича. Так надійшло завірені доктора юридичних наук, професора заслуженого працівника освіти України, завідувачки кафедри загальноправових дисциплін та міжнародного права Одеського національного університету імені Мечникова. ФДК Джон завірені позитивні. Також надійшли завірені від кандидата політзавідувача кафедри міжнародного права Львівського Національного університету імені Івана Франка Василя Миколайовича Рипецького. Завірені позитивні, зауважень немає. У всіх завіреннях вказується, що дисертація відповідає всім встановленим вимогам до такого роду робіт, і автор заслуговує на присудження степеня доктора філософії за спеціальністю 081 права. Шановні члени спеціалізованої вченої ради, чи є запитання до здобувача? Немає? Дякую. Тоді я запрошую вас до дискусії. Хто бажає виступити, висловити свою думку дисертації і проведеного захисту. Хто бажає? Мистер Гудник, господин Професор Гудник. Будь ласка.
Thank you, dear chairman. Actually, this is very good dissertation. We observed a very impressive text of the dissertation, and we listened to very impressive presentation. This dissertation, to summarize it, I said before, this dissertation is on time because we have armed aggression, Russian Federation against Ukraine. So this dissertation for us is very important because the dissertation show for us, for Ukraine, a direction how to resolve that problem. I mean, problem how to prosecute person who commit international crimes, how to prosecute person who commit some other crimes, but that fled from Ukraine. That dissertation conducted in very high methodological, theoretical level. And as final conclusion, I just want to again to summarize and more in detail that the dissertation out judicial principle in international law by Kos'yanenka submitted for the degree of doctoral of philosophy in specialty 91 law field of knowledge. 9 law shows that that work has performed at high theoretical methodological level and meet the requirement of the Act of Cabinet of Minister of Ukraine number 44, dated in 12 January 2022, an approval of the procedure of awarding the degree of Doctor of Philosophy and cancellation of the decision of the one-time specialized academic council, scientific council of the institution of highest education, and its author, Olegovich Kos'yanenka, deserved to be awarded the degree of Doctor of Philosophy in specialty 81 law. So here I just want to congratulate Olegovich Kos'yanenka and his supervisor, his Professor Andreychenko, with excellent, with very impressive and dissertation with very nice defense, and I believe that the dissertation will be continued in other scientific steps, and that dissertation will show our science forward. That dissertation open our science forward, so it's for us very important. So again, congratulations with very nice work with very nice defense.
Thank you, dear Professor Gudnik. Who's the next? Please, Professor Polypenko.
Дякую, шановний пане голово. Якщо ви дозволите, я спробую і українською мовою теж. Так, щоб було, як кажуть, 50-50. Ну, перш за все, хочу відзначити ще раз дуже високий рівень роботи, блискучі відповіді автора дисертації на запитання, на зауваження і опонентів, і рецензентів. Фактично автор повністю є в матеріалі. У зв'язку з тим я декілька собі зробив от таких нотаток, які я вважаю, що вони ще більше підкреслюють важливість того дослідження, яке провів автор. Ми не можемо не применшувати сьогодні значення цього досліджування, оскільки застосування і дослідження принципу «dederat judicare», тобто або видай, або здійсни кримінальне переслідування, воно фактично у всій роботі показується через призму сьогоднішньої російсько-української війни, російської агресії. І в цьому є дуже велике значення практичне роботи автора. Друге, я хочу ще раз відзначити важливість висновків, які зробив автор. Я вважаю, що це є надважливі висновки, що стосовно підхід про так звану третю альтернативу цього принципу, передати особи для здійснення розслідування до Міжнародного кримінального суду або трибуналу. Ну, тут я хотів би детальніше зупинитися, оскільки це є дуже важливим і показує ще раз те, що автор дуже ґрунтовно підійшов до дослідження цього принципу. Що таке Міжнародний кримінальний суд? Так, це постійно діючий орган міжнародної кримінальної юстиції, який сьогодні є. І передача осіб, яка підозрюється у скоєнні найважчих міжнародних злочинів, так це теж є частина виконання цього принципу, як би він не називався. І це, до речі, важливий висновок для України, бо Україна до цього часу не ратифікувала Римський статут Міжнародного кримінального суду. Дай Бог, щоб до кінця цього року ратифікувала, як кажуть вже в Офісі президента, ми про це вже 20 років говоримо. Інше питання. Автор вірно підмітив, що передача можлива в рамках цього принципу і в рамках третьої альтернативи поки що не лише до Міжнародного кримінального суду, але і до трибуналу. До якого трибуналу може хтось запитатися зі сторони? Трибунали по Руанді і колишній Югославії вже не діють. Та ні. Сергій Олегович правильно відзначає, до трибуналу абсолютно як органу окремого міжнародної кримінальної юстиції, який може бути створений ad-hoc, і який ми всі тут з вами, я переконаний, підтримуємо те, що він був створений. Ми говоримо про ad-hoc міжнародний кримінальний трибунал для покарання осіб, відповідальних за вчинення злочину агресії проти України. І тут так само автор уже передбачає, що такий трибунал буде створений, і що цей принцип теж буде застосовуватися у зв'язку із цим трибуналом, із його провадженням. І те, що створення майбутнього цього трибуналу є безальтернативно для світового співтовариства, ми всі з вами переконані, і автор у своїй дисертації теж це підкреслює. Тому, безперечно, я хотів рекомендувати автору, Сергій Леович, ви не зупиняйтеся над цим дослідженням, ви дуже глибоко в темі, в матеріалі, ви багато дослідили з теорії, спочатку, як ще колись Єгор Гроцій починав фактично формувати основу для того, щоб цей принцип з'явився так у своїх працях, але коли це було, по латині, так він добре звучить, «одедеро юдікаре», але це є дві альтернативи. А я ще раз підкреслюю важливість того, що ви вказуєте на третю альтернативу. То, можливо, оця практика, що зараз буде в Міжнародному кримінальному суді, яка буде практика в майбутньому трибуналі із застосуванням слова передачі, surrender по-англійськи, це не extradition, ми це розуміємо, і це різні правові категорії. Конституційний суд у своєму висновку в 2001 році ще визначив, що передача особи і видача особи – це є різні правові категорії. То, можливо, якесь треба буде, я думаю, що вам не треба зупинятися, працюйте далі, можливо, саме ви колись у докторській роботі на доктора юридичних наук обґрунтуєте, що цей принцип має складатися з 3 термінів, а не з 2. Що досить вже навгороці. У нас 21 століття, і саме це буде відповідати сучасному міжнародному праву. І, до речі, це буде дуже корисним для України. Я щиро дякую вам за можливість сьогодні взяти участь у обговоренні вашої роботи. Мені дуже приємно, абсолютно переконаний, ще раз підтверджую, що автор заслуговує на присудження йому ступеня доктора філософії в галузі права. Повністю підтримую і колегу Гутника, який щойно теж про це заявив. Тому я бажаю вам подальших успіхів і не залишайте цю справу. Це та справа, що ви досліджуєте, є дуже важлива безпосередньо для нашої держави, для відновлення справедливості в сучасному міжнародному праві. Дуже дякую вам, пане голово, дякую вам за можливість виступити.
Дякую, професор Пилипенко, за вашу детальну оцінку дисертаційного дослідження. Професор Пасічник.
Дякую, шановний голова. Обрана тема є вкрай актуальною як для України, так і для міжнародного права в цілому, особливо наразі. Обрана тема є дуже плідна для подальшого дослідження. Ми сьогодні побачили, що дисертант зміг вловити саму суть вкрай актуальної проблеми. Висновки дисертанта викликали неабиякий інтерес. буду голосувати позитивно. Чекаємо вашої докторської. І вважаю, що дисертація здобуття ступеня доктора філософії за спеціальністю 081 права, що дисертант заслуговує цього ступеню. Дякую за увагу.
Дякую, дякую. Будь ласка, професор Кузьмін, будь ласка.
Оскільки у нас 50-50, дозвольте англійською, якщо можна. Сергій Олегович, it's a great pleasure to have such an experience here, and I'm really thankful for such kind of an opportunity. I believe that the author of the manuscript is rather demanding to himself. That's because whenever I was trying to analyze the text of the work, I was thinking that okay, here's the necessary and essential minimum of the work, but a little bit more. And this a little bit more is reflected in the quantity of the publications. Okay, it is something about the English language, and is the first time ever we've been experiencing such an event, and that might serve as a symbolic basement for the rise of the quality of the research here in Ukraine as well as in the world, and that is the ground for admiration. That is something that goes to the number of sources that we have to analyze. That is something that is enshrined in such a conclusion that we might see. That is something that would be in a very complicated task. That is something that might be reflected in a lot more number of features, and that is something that is characterizing this work as, you know, and its author in a very decent and positive way. Therefore, I'd like to support the efforts of author on his long and thorny road towards the accomplishment of such a monumental work, and once only may know how hard and tough it is in Ukrainian, and especially how hard and tough it is in English, and therefore it's a great reason to admire. Thank you so much.
Thank you, Mr. Kuzmin. I totally agree with you, with dear opponents, and with dear reviewers. The present problem is becoming more and more relevant in connection with the situation which is now in Ukraine. I think it explains the great theoretical and practical importance of this research. To my mind, the task which was appointed by author was solved, and of course, based on the result of reading of the text of the thesis, and also the success defense today, your presentation, I support this thesis, and I hope you will go on your research in this area, because the principles of international law become more and more important for our country, for the world. Thank you, thank you. Шановні колеги, зараз нам треба прийти до проведення відкритого голосування щодо присудження Кос'яненка Сергія Олеговича ступеня доктора філософії галузі знань 08 права за спеціальністю 081 права. Прошу вас проголосувати. Хто за присудження дисертанту ступеня доктора філософії в галузі знань 08 права за спеціальністю 081 права? Відкрите голосування. Дякуємо. Дякуємо. Хто проти? Немає. Хто утримався? Немає. Дякую. Рішення прийнято одноголосно. Дозвольте оголосити рішення про присудження здобувачу ступеня доктора філософії в галузі знань 08 права за спеціальністю 081 права. Нам необхідно відкритим голосуванням прийняти означені рішення. У кого буде зауваження, змін, доповнення до проєкту рішення, які була роздана? Є пропозиції прийняти за основу. Нема зауважень? Дякую. Хто за таке рішення? Дякую. Дякую. Хто проти? Нема. Хто утримався? Немає. Дякую. Прийнято одноголосно. Прошу заслухати рішення спеціалізованої вченої ради про присудження доктора філософії. Рішення спеціалізованої вченої ради про присудження ступеня доктора філософії. Спеціалізована вчена рада Національного університету Одеської юридичної академії Міністерства освіти та науки України міста Одеса прийняла рішення про присудження Кос'яненку Сергію Олеговичу ступеня доктора філософії в галузі знань 08 права за спеціальністю 081 права на підставі прилюдного захисту дисертації на тему принцип аудитера аудиюридикара у міжнародному праві. 15 липня 2024 року Кос'яненко Сергій Олегович у 2019 році в Національному університеті Одеської юридичної академії здобув степень вищої освіти бакалавр за спеціальністю права з відзнакою. У 2020 році в Національному університеті Одеської юридичної академії здобув степень вищої освіти магістр за спеціальністю права з відзнакою. У 2021 році закінчив університет ЕСКЕС у Сполученому Королівстві за спеціальністю права. А також у 2022 році здобув степень магістра у Королівському коледжі Лондон з відзнакою. У 2021 році вступив до аспірантури Національного університету Одеської юридичної академії спеціальність 081 права. Наразі працює в освітній корпорації у головному офісі в Лондоні на посаді керівника проєктів. Також у 2024 році працює з 2024 року працює в Міжнародному гуманітарному університеті на посаді віце-президента з інноваційної діяльності та маркетингу. Дисертацію виконано в Національному університеті Одеської юридичної академії міста Одеса. Науковий керівник, доктор юридичних наук, професор Андрійченка Світлана Сергіївна, професор кафедри міжнародного та європейського права Національного університету Одеської юридичної академії. Основні положення та висновки досліджень відображено в 12 наукових публікаціях, в тому числі 4 статтях у наукових періодичних фахових виданнях, рекомендованих МОН України, 2 статтях періодичних наукових зарубіжних виданнях, а також 6 тезах доповідей на науково-практичних конференціях. У дискусії взяли участь голова та члени спеціалізованої вченої ради, зауважені та подані пропозиції викладені в письменній формі в нашому рішенні. В результаті відкритого голосування за 5 членів ради, проти немає, тих, що отримувалися, немає. На підставі результату відкритого голосування спеціалізованої вченої ради Національного університету Одеської юридичної академії Міністерства освіти і науки України присуджує Кос'яненку Сергію Олеговичу ступінь доктора філософії в галузі знань 08 права за спеціальністю 081 права. Хто за? Хто проти? Немає. Хто утримався? Немає. Прийнято одноголосно. Вітаю здобувача присудження ступеня доктора філософії в галузі знань 08 права за спеціальністю 081 права. Є у кого зауваження щодо порядку проведення засідання? Я думаю, при кінці слова надаємо нашому здобувачу. Будь ласка.
Дякую, Шмитало Леонідович. Як Володимир Павлович підмітив, 50-50 будемо цього правила притримуватись. Dear members of the Specialized Academic Council, thank you very much for your attention to my dissertation. I'm very grateful for all your comments, suggestions, which will be, of course, taken into account into my future work. I want to express my sincere gratitude to the university administration for allowing me to prepare and present the thesis. It is a pleasure to express my gratitude to my supervisor, Professor Svetlana Andreychenko, my respected opponents, Professor Vitaly Gutnik and Volodymyr Polypenko. Many thanks to respected reviewers Eduard Kuzmin, Yelena Pasechnik. My sincere thanks to, of course, to Professor Behruz Hashmatullah, Head of Department of International Law and Comparative Law and Chairman of the Specialized Council. I'm greatly thankful for the support I received from my family and friends. Thank you very much for your attention and for your time today.
Thank you. Дякую за роботу. Оголошую засідання. Всім желаю мира, добра. Дякую. Бережіть себе. Дякую.